Hi friends from around the world. How are you? So this is now the second part of the UPC starting up kit. If you haven't seen the previous one, please go for it. It will enhance your learning experience, learning curve. Now, I can't remember whether I told you through, I think, the most important lesson, most important takeaway, but it is worthwhile repeating anyway. So the general principle here is that, and the good news, so to say, is that the filing process, examining process, and even administrative review process will not change very much substantially, meaning that you can file at the EPO as before, it will examine your patent as before, the criteria will remain as before, and you go to the EPO the Revision Board of Appeal as before, and then, well, some changes come in with the litigation, right? But it is not that I have to focus now on, well, you have to present it in that way, on that way, or, you know, I will not focus in my videos here on the substance. You know it already, so it doesn't change anything. It has rather a strategic importance whether you want or don't want to be part of that system and what that system afterwards represents, and what are the case law of the UPC you will be interested in, because it will have impact all over. So that is one important takeaway, and hopefully you will get more quiet and less anxious with regard to the new system. Now let's come to the periods I talked you through the preparation period in the last video. Here on the screen you see there are in fact three phases. One is the preparation phase, the one I mentioned, so to say, in the previous video, and which started on the 17th January of 2022 with the presentation of Austria, the deposit of the preparation protocol, right? So this will take 6 to 8 months previsibly. We don't know exactly. It has to be determined by the committee, by the corresponding committee. And it will last, I don't know, October, November 2022 perhaps. And then Germany, at a certain moment around that, Germany will present its ratification deposit, and then a setup phase begins. That was the system in 2017, and I don't think, and where we thought already it will go live, and it was not the case, due to the Constitutional Court. So now the setup phase will be probably again somewhere between 3 months, but with the beginning of the setup phase, the court already exists and we can interact with the court. So this is 3 months, and then in 2023, beginning probably after the setup phase, there will be a transition period between 7 and 14 years. So it seems very long, right, that transition period, but it is set up like this, and I will come to it, what is its importance with regard to your patent. Let's come into the second slide, which are conditions for opting out here on the screen. So what is it that you can opt out, and when you cannot opt out, what are the conditions for it? If you cannot opt out, why would you care about? So you need to know what are the conditions for opting out in the first place, right? So in order to be able to opt out of the UPC system, you obviously need to have a valid European patent in all the contracting member states. Now, the contracting member states are not all of the EU, probably it will not be the case. it will be only part of the total member states. So therefore, I focus always on the contracting member states, and you should know them. Here on the screen, you see the map, the graphic down, and you see in dark blue those who have ratified the UPC and the UP agreement. So they will be in light blue. There are some who have signed the two agreements but have not yet ratified. So probably they will be ratified in the near future, and they will be in as well. Meaning that in total, the dark blue and the light blue are 22 member states. What you see is Poland is not yet in, Spain is not yet in. So these are two countries, bigger countries, which are not yet in. Spain, due to the language issue, I will not get into it. And the Britain is out, right? The UK is not in. Now, during the setup phase or during the transition period, you need to have this European patent. And your claims, so it is a unitary title, and your claims in all the contracting member states, right, must be identical. Otherwise, you will not have a unitary title. And one of the most important issue is that a litigation has not started. So litigation can be on your own initiative, or it can be on the initiative which has nothing to do with you as a third party who introduce such a claim at the unitary patent court, for example, in an injunction, maybe an injunction against you, and then alea jacta est, everything is gone. You cannot opt in or opt out. That is an important issue. So it does not only depend on you, it may depend on others. That's what I want to transmit you. So you may be limited by the choice, not by yourself, but by others without wanting it. And that is the important issue here to learn. Now, let's go to the general principle here in the screen so that you see it. Once you have the conditions for opting out, you can either do nothing. What happens if you do nothing, if you do not opt out? Well, European patent enters into the new UPC system. That is what happens. So if you do nothing, it enters into the UPC system. If you opt out, nothing changes for you really with regard to the previous system. So a litigation in national courts, and you have a bundle of national patents, right? So this is easy for you to take. So this is the general principle. Now here on the screen, when to opt out and opting out during the setup phase. So in the graphic here on the left, we have the setup phase at the left, and then a big line, and then the transition period begins, and it ends at a certain moment where the interrupted line, vertical line is. Now, if you opted out of the UPC during the setup phase, so during the first moment, the litigation is, so that is the green line, right? The green line, which is on the downside and comes later up. Litigation is done in the national courts until the end of the transition period. And after the transition period, litigation is done in the UPC, in the European Unified Patent Court. So that is a consequence of when you opting out during the setup phase. You need to be present. You need to know what happens, what will be the consequence of it. Now, what happens if you opt out during the transition period? So therefore, it is important to know the different periods, right? Here on the screen, you have the same graphic now with a different consequence. If you opt out during the transition period, this is the gray, the bright gray line. If you opted out during the transition period, you will be outside during the transition period, but you will not come in to the UPC system after the transition period ends. So that is a different, that is a different consequence depending on when you decided to opt out of the system. Opting out, so is the only possibility. You can opt out, and we'll come to it, withdraw the opt out. So is that clear for you? The opting out, when, at what moment, and with what consequence? Now, where and who can opt out? Here on the screen, you see that you have to opt out at the registry of the Unified Patent Court. And the Unified Patent Court, now starts, so to say, existing with regard to the setup phase, and during the beginning of the transition period, it will be fully operational. Now, one issue is in order to opt out, do you need, if you have, for example, a exclusive licensee, do you need to have the agreement of that exclusive licensee in order to make the opt-out? No, that is not the case. You do not need to have that agreement from it. It is up to the patent owner. If you have more than one patent owner, both patent owner or three or whoever it is, they must agree on it. In any case, I advise against joint ownership, right? Now let's come to the withdrawal of the opting in. Here on the screen, you see that you can withdraw the decision of opting out at any time. So meaning that you will come into the system from that moment onwards. Well, here again, if in the meantime, so if you once have opted out and there are some proceedings pending, so you cannot withdraw, then again, no, that is, you have to understand that the opting out or withdrawing opting out at the same time, they can depend on you, but they do not depend exclusively on you. It may depend on how are acting others in the, for example, in the national court, right? So you can also withdraw your opting out decision after the end of transition period to become part of the UPC system. So there is a certain facility wanting you to come, or inviting you to come to the new UPC system. Any case, if you are opting out and you are still with the national courts, you can be sure that the national courts will pay attention to what will be the judgment of the UPC, of the Unified Patent Court, in order to get some guidance for the future, and they will observe closely how will go the case law of the Unified Patent Court. Now, you may be interested in what happens with SPC, right? The supplementary, here on the screen you have it, the supplementary protection certificates, so SPCs. well, these are a kind of extension of the patent right in order to compensate for the approval of, for example, pharmaceuticals or plants, some things which depend on the corresponding government agency, and would reduce the patent time of the 20 years. So there are supplementary protection certificates. Now, if you opt out of the patent, the supplementary protection certificates, the SPCs, they were opted out as well. After the European patent has expired, though, the opt-out of the SPC based on it is still achieved by opting out the expired patent. Now, the SPC, for the moment, we don't have them in the unitary patent, but we think the Commission is working on it, and we soon will have it. So the SPC is something very consolidated, and the pharmaceutical industry is, well, expecting that the Commission is moving on it. So if you see on the opting out, this is about the capability to understand opting out, the strategic importance. We will come a bit later onto it. Let me wrap this up for you. First takeaway. In substance, nothing really changes with regard to the EPO proceedings beforehand. So you will have to present an examining process. The criteria are the same. The examiner will do the same thing. We have already the EPO ongoing since the last 40 years, so nothing really changes on substance. If you opt out, nothing changes with regard to the EPO, right? So with the EP system, the European patent. So you will continue to have a bunch of patents, and you will litigate in the national courts as before. So if you don't want to change anything, you have the tools to opt out of the system, and it will not change anytime soon. It may be after the transition period, but this is maybe 14 years away, so you do not care about this very much. The third takeaway is that the opting out is not exclusively your own choice. It may be the choice of others who decide for you. If they decide to make an injunction against your patent, your client's patent, then the choice is being done. So it is not anymore up to you to choose the one or the other, but the choice is being done. So this is an important issue in order to get yourself, your mind clear whether you want or you do not want to make the choice, rather than leaving it up to a third party to make the choice for you or for your client. So hopefully you enjoyed this video. Thank you for tuning in anyway.